Welcome back, everyone. Time again to check in with Gilbert Adams for our Ask the Attorney segment. Thank you so much for joining us.
Thanks for having me.
Let's get started. First question, I owe a balance on my vet bill that I haven't been able to pay for a couple of years. He's charging me 21% interest, which really adds up to over $600. Is that legal?
Well, what we're talking about here is usury, and this is called usury, and a lot of people don't know this. You'd be surprised at the number of merchants that are not aware that you cannot charge people more interest than allowed. Texas law allows, absent a written contract, 6% interest. A lot of merchants charge 18%, and yet they don't have that written agreement. And when that happens, when a merchant is charging you more than 6%, if you haven't agreed to it, then there can be stiff fines and penalties, including up to forfeiture of the principal balance. So it's important to know that you must have a signature to charge over 6%.
Okay, so it is legal as long as the customer's agreeing to that.
It's legal as long as the customer has agreed in writing and it's no more than 18%.
Okay, question number 2, what exactly is arbitration and should I agree to it in a contract?
You know, arbitration is something that we as lawyers, trial lawyers, are not very, we don't like to see that because you've taken away the rights of the jury to hear the case.
Right.
When you have an arbitration, you've agreed that a lawyer from Houston, Dallas, somewhere, maybe even Beaumont, will decide the case, and you miss all the experiences that a jury brings to it. So we're seeing this a lot in smaller consumer contracts, such as your phone bill, such as your cable bill, but it's not something that I as a lawyer can recommend anybody agree to.
Right. Okay. And last question, my soon-to-be ex-wife stole my jewelry, furniture, and appliances out of my house. Can I sue her for stealing them?
You know, technically you can sue her. However, this is something that's going to be resolved with the many other issues that probably exist in the divorce court. And you know, the questioner assumes that those items are his. You have the inception of title rule that applies, and whenever that merchandise, those appliances are acquired, that determines the presumption about whose it is. And so it may not be his, even though he's gone out with his paycheck and bought it.
So that's really something that will be ironed out in the divorce, not a separate case?
In the divorce court, no need to file a separate case about it. All
right. Well, thank you so much, Gilbert. And, of course, if you'd like to submit a legal question for Gilbert to answer, you can email us at asktheattorney@fox4beaumont.com, or you can call the law office of Gilbert Adams at 835-3000. Time now